A comedy of errors in the clerk's office, combined with an attorney's failure to investigate, leads to a court dismissing a case. When the plaintiff asks the court for relief over a year later, he finds the delay is no laughing matter. In Brandon v. Chicago Board of Education. Lorenzo Brandon filed a lawsuit against the Chicago Board of Education for violating his rights under the Americans with Disabilities Act. Brandon's attorney worked for the law offices of Paul F. Peters. These attorneys entered their appearances and provided the office's mailing address. The court clerk mistakenly sent notices to a different attorney, Paul A. Peters, who alerted the court that he wasn't involved in the case. But the clerk kept mailing Paul A. Peters documents, including notices for 2 status hearings. During this time, the board had filed 2 motions and served copies on Brandon's attorneys, so the attorneys should have been expecting court orders. The second hearing took place about 4 months into the case. Because Brandon's attorneys didn't attend, the court dismissed the case for failure to prosecute. The clerk also mailed this dismissal to Paul A. Peters. About a year later, Brandon's attorneys went to court to look at the docket and discovered the dismissal. Brandon filed a motion to vacate pursuant to Federal Rule of Civil Procedure 60A just over a year after the dismissal. The clerk's office filed the motion with the wrong case, resulting in additional confusion, delays, and Brandon refiling. The court granted the motion, so Brandon notified the board that it didn't need to go to the hearing. The board went to the hearing anyway and convinced the court to change its order. Brandon appealed. Rule 60A applied to errors in an order or judgment, not errors in which a clerk mailed notices. So Brandon instead based his appeal on Rule 60b-6, Rule 60's catch-all provision.